When it comes to the Fourth Amendment that we just read, the basic requirement of search and seizure, there is an exception to it. Prior decisions of this court, however, Supreme Court that is, have emphasized that exceptions to the warrant requirement are, quote, few in number and carefully delineated. Assuming the terrorist stop is some type of firearm, where you can now modify and add things like flashlight, laser, so on and so. Exigent circumstance will be the modification or accessory you can add to it. What is exigent circumstance? Is what most people consider mental toil that causes them to ignore black and white, and they get screwed over for it. When they pass away, their children suffer for it. It's crucial that you know this now, so that it's easier for you to pass it on to those who are coming after you. A third exigent circumstance recognized by res judicata that is still active. You keep something alive and you bring it to life by expressing it verbally. One of the powers we have compared to any other flesh and blood on this earth, the power of words. And that is something that you can use to your benefit. So long as you get straight to the point, keep it simple and repeatable. That way, there's no reasonable doubt. Hello, 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 beautiful people. There's always an exception. Some cases, more than one circumstances, it basically skips the line of the general expectation. The parent has an exception for the children. Husband has an exception for the children. So does a wife. Establishments, so and so. In society at large, any type of man or woman acting as a governmental capacity, when interfacing the everyday man, as rules and standards. Those rules and standards, beyond how said government is organized, which is in the articles, those rules and standards that limits the interaction of governmental actors among the everyday man is in the general sovereign immunity of the people called the Bill of Rights. In this case, one of the more popular, next to the Second Amendment and the First Amendment, is the Fourth Amendment, whereby the right of the people to be secured in their persons, houses, papers, and effect against original searches and seizures shall not be violated, and no warrant shall issue, but upon probable cause, supported by oath or affirmations, and particularly describing the place to be searched and the person and thing to be seized. In short, no one can have persons or their effects or their papers searched or seized unless there's a warrant. That's the standard. Meaning there's a line to go through certain steps for you to get to a desired outcome. The desired outcome of any governmental actor in this particular instance is to search or seize someone physically, someone's business, someone's documents, someone's properties, or anything that's an extension of natural man or woman called the people. But there are exceptions to this. That exception is what governmental actors has granted upon themselves because the everyday man and woman are generally speaking aloof to these things called the constitutional secure right. And with time, most people care less for it, generation after generation, because they aren't too aware of the fact that there are certain foundations that controls the confines of what makes America America, of what makes them comfortable in the position that they have inherited one way or the other. Most, even the so-called old generations, are aloof to the fact that there are certain things that if you do not use it, you will lose it, because the intent of those who established this thing most people live in is freedom. But of course, the general law of correspondence and polarity would always say where there is one thing, there would always be a balance to it. whether you consider it good or bad. The balanced correspondence that's been preserved herein within the Bill of Rights, meant to protect and to perpetuate the integrity of the everyday man and woman to simply be left alone, balance to it, are the things that are subsequent, created through res judicata, created through common law, guided through the state legislatures. If those who are governed, aka the people, are aloof to this, very much like how a parent has a standard at home. You can't go to the playground until you finish your homework. Child says, hey dad, hey mom, I finished my homework. That's the exception. Finish your homework and go to the playground. Otherwise, no such thing as a playtime. But the man and woman who is the parent failed to double check the homework because, well, they're too busy with their daily woes trying to figure themselves out. So the act of parenting and discipline is just something on the side that they don't really enforce until they're upset or they feel things are getting out of hand. Same thing applies with this thing called rights. Those who have the power, those who are the head of the household within the government are the people, because their consent is required for any government to function. But they're far asleep and they're so concerned with many more things in life, which is understandable. Because life, let's face it, is really not the most easiest thing. Although the majority of it naturally is easy, we are the ones who make it complicated. And nonetheless, many people are stuck with the complicated portions of life. And these things on pen and paper are as good as irrelevant to them. Therefore, those who are supposed to be bound and limited by this simply creates the loophole on pen and paper. By function, they will blatantly violate it. But when it comes to pen and paper, they will point out the loophole as an exception, aka an excuse or a supposed valid reason as to why they can just jump the line, ignore the basic standard that is required. Because the ones who are the everyday man or woman whose consent are required to be governed don't even know the power they have. Exceptions. Exception is a thing, concept, a person that does not follow the rule or is excluded from the general statement condition. Constitutional laws are considered something called general laws, not special laws. Valentine's, 3rd edition, page 1086. General law, a statute having a uniform operation. Uniform meaning everyone is bound by it. But you might go, wait, I thought you mentioned that the Constitution is general law. Why are you stating it's a statute? Of course it is. The first statute ever passed by the de jure Congress of the United States was the Constitution. If you go into congressional records and you look at the first few statutes passed, they were the Constitution of the United States. gov.info.gov/help/statutes. This is a former governmental website. What is available? Volumes 1 to 64, which constitute of the time period 1789 to 1952. The statute at large includes the text of Declaration of Independence, Articles of Confederation, the Constitution, amendments to the Constitution, treaties with Indian, blah, blah, blah. You can formally go to the Library of Congress, ask them for the volume between 1789 and 1952. It will make it easier. Just ask them for the certified copy, the United States Constitution within the Library of Congress, and it would automatically come with the volume and the date and the sequence of when it was preserved therein as statute. Moving on. So for those worried about whether statute applies to natural person or artificial or not, what you ought to consider is not that rhetoric. What you ought to consider is whether that statute is a special one or a general one. That's the key, because even the Constitution mentions that general laws would always supersede special laws, which are private laws, administrative in itself, which links to the concept of natural persons compared to artificial artificial persons, to which the Constitution itself also delineates by using the term the people compared to persons, which one can further elaborates into everything else beyond the first Bill of Rights, where the word quote persons are used more frequently than the word quote the people. But that's another matter for another day. Moving on. General law. A statute having a uniform operation. General law. That is a statute operating equally, hence general law, or alike upon all persons. Entities. Whenever the word entities follows the word persons, know that this word persons delineate both natural and artificial. They will make it easier by saying all. Then they're not leaving it vague as to artificial or not. Then they went to entities, which we know are artificial. So this word persons, which is qualified by saying all persons, lets you know that it includes natural also. Alike upon all persons, entities, or subjects within the relations, meaning whatever that body of law refers or relates to. Conditions, the rights preserved therein or restricted. And circumstances. Well, the searches of houses, papers, persons, effect against unreasonable searches is what we're speaking of here. Well, the right of the people to be secured in their persons, houses, papers, in effect against unreasonable searches without warrant, and oath specifying the particularity involved. That's the circumstance involved in spoken of here. Prescribed by the law. What law? The Constitution, particularly the Bill of Rights, the first 10 amendments. Or affected by the conditions to be remedied. Which brings us here to exception that we were reading. Exception is a thing, concept, or person that does not follow the rule. What rule? The Constitution. What rule? General law, delineating the conditions behind searches and seizures. Again, exception is a thing, concept, or person. Person being representatives of any type of governmental entity. The concept being the judge-made laws in the state legislatures that kind of act as an opportunity to sort of shortcut things without the formality of it as an exception. That does not follow the rule or is excluded from the general statement or condition. General statement or condition is referring to general laws. Valentine's 3rd edition, page 892. Exception. Someone or something excluded. When it comes to the 4th Amendment that we just read, the basic requirement of search and seizure, there is an exception to it. Most who might have been watching this channel know we've spoken of that in the form of Terry stops. And Terry stop is intertwined with something called exigent circumstances. I trust most know what Terry stop constitutes then. But in short, it's the pat down of outer layer in a short period of time or the search of a weapon under the circumstances that there are known facts relating to past, current, or anticipated crime. That's the loophole to probable cause where no warrant is required. If it exceeds those 4 basic requirements, then it's not a Terry stop, and therefore the search or seizure is unlawful. Assuming the Terry stop is some type of firearm, where you can now modify and add things like flashlight, laser, so and so. Exigent circumstance will be the modification or accessory you can add to it. What is exigent circumstance? Welsh versus Wisconsin, 1984, is yet to be overruled. United States Supreme Court, case number 82-5466. Prior decisions of this court, however, Supreme Court that is, have emphasized that exceptions to the warrant requirement are, quote, few in number and carefully delineated. We'll give you where they derive that from. When attempting to demonstrate an urgent need that might justify a warrantless search or arrest, Indeed, the court has recognized only a few such emergency conditions, which are a hot pursuit of fleeing felon, meaning the emergency circumstance that can cause someone to be seized and searched without probable causes if a felon is fleeing. So that means there has to be a prerequisite where that man or woman who's running or fleeing is known to be a felon. But there are other res judicata that emphasizes that they don't necessarily have to be a felon, so long as they're suspected. The second exigent circumstance is destruction of evidence, meaning if they suspect that an evidence that will lead to a crime or lead to the finding that a crime has occurred that they suspect will be destroyed. Remember, the suspicion itself is not the crime. That's very important, which is what many municipal employees will try to assert as their reason to violate the Constitution. No res judicata affirms that suspicion itself is a crime. If the facts stipulate, known to the man or woman during the arrest or seizure, that a crime has occurred, is occurring, or is about to, in this case, based on that fact of past, present, and future crime, that there's an evidence relating to the fact known, then an exigent circumstance is triggered as an exception to the probable cause. This is very important. This mental toil and mental deductive reasoning, this basic mental deductive reasoning is what most people consider mental toil. It causes them to ignore black and white, and they get screwed over for it. When they pass away, their children suffer for it. It's crucial that you know this now, so that it's easier for you to pass it on to those who are coming after you. A third exigent circumstance recognized by res judicata that is still active till today is ongoing fire. In other words, public safety, anything relating to it. One of this example is just ongoing fire. There's certain things where they can assert that, hey, we're doing it for the purpose of public safety. The extent of that is now up to you, and has actually applied only the quote hot pursuit doctrine to arrest in the home. Consistently with the approach, the lower courts have looked to the nature of the underlying offense as an important factor to be considered in exigent circumstances calculus. So if someone approaches you and say, hey, there's a suspicious person here, or there's a call for a suspicious person, they're letting you know that the alleged underlying offense is that someone called and said someone was suspicious, and that maybe you fit the description. That does not trigger a warrantless search, because the allegation of a caller, which likely lacks indicia of reliability, or that someone is just standing in front of you telling you that someone called regarding a suspicious man or woman, that itself is not an offense. But if you don't know that, but you have this hunch something is wrong, while someone approaches you and tries to basically pull the wool over your eyes, most you can do is just get upset without invoking certain basic things by simply asking, is this a consensual encounter? By simply asking, is there an exigent circumstance involved? Over and over and over. Use the tool of a hammer. Accordingly, articulate your exercise of a constitutionally secured right. You keep something alive and you bring it to life by expressing it verbally. One of the powers we have compared to any other flesh and blood on this earth, the power of words. And that is something that you can use to your benefit. So long as you get straight to the point, keep it simple and repeatable. That way, there's no reasonable doubt that you waived it or that it does not apply, which will then show mens rea, which is a state of mind, conscious awareness of the other party. In a leading federal case defining exigent circumstances, for example, the en-banc United States Court of Appeal, which is just different acting judges listening to one thing at once and making a decision collectively. The United States Court of Appeal for the District of Columbia Circuit recognized that the gravity of the underlying offense was a principal factor. The gravity of the underlying offense was a principal factor to be weighed. Berman versus United States. Without approving all the factors included in the standard adopted by the court, it is sufficient to note that many of the lower courts have also considered the gravity of the offense an important part of their constitutional analysis. The underlying factor, the underlying alleged offense, qualifies this thing called exigent circumstance, which can be used as an accessory attached to someone who intends to do a warrantless search or seizure. You must know that. But of those courts addressing the issue, most have refused to permit warrantless home arrests for non-felonious crime. The exigent circumstances exception is narrowly drawn to cover cases of real and not contrived emergencies. 9 out of 10 circumstances that municipal employees will bring up to you are just some speculative, subjective feelings involved. Feelings of ego, feelings of, well, someone felt this way, or someone said this, someone said that. Therefore, you look suspicious. Or, hey, you just look suspicious and we got a call. That's contrived. That's not a real emergency. And that does not qualify for warrantless search procedures when it's that of a home, person's papers, or effect. The exigent circumstance exception is limited to the investigation of serious crime. It was up here that I mentioned that homes cannot be searched if the underlying offense is not a felony. And then it goes on to say that the emergency itself must be real. Must not be some subjective crap. Misdemeanors are excluded. So it must be a felonious crime that is alleged as the underlying factor for exigent circumstances to be triggered. So it must be a felonious crime that is alleged as the underlying factor for exigent circumstances to be triggered. So it must be a felonious crime that is alleged as the underlying factor for exigent circumstances to be triggered. Very, very important. This is according to the Supreme Court. So the hot pursuit of a felon, an ongoing matter of public safety, needs to be prioritized like an ongoing fire, or the potential of destroying an evidence, which will trigger exigent circumstance, which is the warrantless search. That is an exception to the requirement of the Fourth Amendment, is only valid if the underlying issue is real, not speculative, and is not contrived by some subjective emotions or need to be under control, which most municipal employees are conditioned to stay under control, even if it means presenting falsehoods, being emotional themselves, or inciting emotions in you, the everyday man. Exigent circumstances only triggers, warrantless searches only triggers if the emergency is real, not subjective, not emotional, not based on some ego and to feel power that was deprived during childhood, or because their wife wasn't giving them any sexual attention, whatever it is that they have in their life that makes them feel less of a man or less of a woman. Whatever they're saying is the reason must be real and must not be a conjecture. And two, it has to be related to a circumstance where a felonious past, current, or anticipated crime is involved. It has to be a felony-related crime, and it must not be conjecture. Those are the two important factors you must keep in mind when it comes to exigent circumstance. Till next time, take care. Best of luck.